I'd like to begin by briefly introducing our distinguished speakers of this afternoon, of the first panel. Maria Manuel Leitão Marques is a member of the European Parliament. Before that, she was a minister of the Portuguese government and a full professor at the University of Coimbra. Karine Cohn, who is with us online, is the Global Program Director for the Center for AI and Digital Policy and the Editor-in-Chief of the European Law Journal. She has taught in various universities in Europe, including Católica Global School of Law in Lisbon. Malte Fearless is the head of EU AI policy at Amazon. Before that, he was senior manager for European affairs of Deutsche Telekom AG. So let's begin, and I'm beginning with you. Maria Manuel, can you tell us something on the legislative process and how, from so different agendas and perspectives, it was possible to reach an agreement?
Yes, very difficult one, but it was possible to reach an agreement between, and at the end is a consensus. I think so. It's, in my opinion, very balanced regulation, AI Act, very difficult to implement, very complex. I hope it is future-proof, but I'm not sure. But there are many delegate acts scheduled in the regulation in order to have some flexibility. But why to regulate AI? It's our first discussion. We discussed a lot during 2 years in the Parliament with a special committee on artificial intelligence. We went to the United States. We discussed with the White House and Congress and so on. We heard from different companies, different perspectives, but we decided to go ahead and to regulate because if pharmaceutical companies, to give you an example, can't put drugs on the market without going through demanding tests, and it's like that in Europe, in the United States, probably all over the world. And even car manufacturers aren't allowed to put cars in the market without safety requirements, such as brakes and seat belts and the others, many others. And so why should artificial intelligence be any different? We need to regulate because there are risks, as it happens in other industries, many risks associated to artificial intelligence. Risk for us, for humanity, for people, not for things. So the risk shouldn't be completely on the side of consumers. It's what the Parliament and the Council and the Commission decided. So you regulate with a risk-based approach, paying attention to the applications with more risk, and for the others, very simple, there are no obligation or very simple obligation or even no specific obligation. Of course, any application needs to comply with some rules, but general rules. So we decide to regulate with this risk-based approach. I'm going only to say the type of risks after we can discuss about them. First, we have prohibited AI practice, where we think that there is an acceptable risk in terms of surveillance of cities or attempts to their fundamental freedoms and rights. The second group, maybe the more complex regulation, is from Article 6 to Article 49, is about high-risk practices. Here we need some comply with a long list of requirements, conformity assessment, and sometimes fundamental rights impact assessment before deploy them in the market. And the third group are the application with limited risks, for which only transparency obligations are required, and the others, there are no special obligations. And when we were discussing this approach in the Parliament, to regulate not the technology, but the use of technology in some cases, some risky cases, we introduce a new chapter for a new problem that we are surprised, not really surprised, but that emerged during the discussion of in the Parliament, that is general purpose AI. And for general purpose AI, it's a different approach, because in fact there are not a specific use case. So it's that maybe can be used in very risk situations or very no risk situations. So we decide, it's a very, very difficult discussion with opposition of some member states, like France, that was not prefers not to regulate, but we decide to regulate with two levels of obligation. One for applications that do not pose significant risks, other rules for the others. So it's in a nutshell.
It was possible to reach.
And also, but there are other parts of the regulation in innovation, to push innovation, exception for
we will talk
small
about that,
so
of course, yes. I'd like to ask now Karine on the Framework Convention of the Council of Europe that was approved last Friday. Can you tell us what is good and what is bad on the final text, and do you think it will be effective at protecting human rights, democracy, and the rule of law?
Thank you very much, Chris, and thank you very much for the invitation. I'm very sorry I cannot be here. I'm actually in Brussels today, and indeed, as you mentioned, today we passed the EUA Act, and last week the Council of Europe Convention on AI. So in this regard, I would say that I'm not sure I would think in terms what is good and what is bad, but what can we do with what we have? So with this framework, I would say that what is very good is that the approach chosen with the Council of Europe Convention is a rights-based approach. What does that mean? Is that we focus on violations of human rights, issues with democracy, and we know there are a lot of issues, for example, with regard to disinformation, and also the rule of law. And we know that, for example, AI can be used by judicial operators. So that's also very important. Where there is, what is very interesting also is that, like the EUA Act, there is a management of risks framework. So this is also very interesting, because we know that from a European perspective, member states will have to comply with both the EUA Act and the Council of Europe Convention on AI, which means basically that we could use the Council of Europe Convention on AI to correct maybe some loopholes in the EUA Act as far as human rights protection is concerned. And it's also very interesting because we know that the GDPR, for example, has a rights-based approach, not a risk-based approach. And maybe we will keep it for the discussion, but I think there could be some uncertainties linked to this risk-based approach, because basically the risk-based approach is a mean to, in the end, limit accountability. And even the rules on general purpose AI, we don't have just GPI rules, we have GPI models rules, we have GPI systems rules, and we have rules for GPI models which poses systemic risks. And the regime for GPI models which pose a systemic risk is less strict than the regime for other AI system regulated by the EUA Act. So we have a whole maze of different legal regimes in the EU Act that we will have to reconcile with each other. And the hope is that the Council of Europe Convention on AI will help reconcile these different regimes. What will be key with the Council of Europe Convention on AI is the declaration that all states, and even I guess for European state it will be in link with the European Commission, will have to submit a declaration with regard to the application of the convention to the private sector. It is, for example, we know that the US will probably have a light touch application of the convention to the private sector. We will see in Europe, we hope it will be a large coverage. But there is also another aspect, and I will finish with that, which is national security. We know that in the EU AI Act, there is a large carve-out regarding national security. What happened with the Council of Europe Convention on AI, it's that it is not exempted, but states are not required to apply the convention to the Council of Europe. So I'm sorry for the legalese, the legal intricacies, but basically this means that states could voluntarily apply the convention to when AI systems are used for national security purposes. And that would be very interesting, and nothing would prevent them to include into their declaration something about the application of the convention to the use of national, regarding the use of regarding the use of AI system for national security purposes. And we know, for example, that regarding the EU AI Act, Austria has raised some concerns regarding national security. What they said basically is that why do we have AI system used for commercial purpose, which would be regulated by the EU Act, and suddenly, because the same AI system would be used for national security purposes, suddenly the EU Act wouldn't apply, while it is the same system and it can also be biased. So I will leave it at that, but that will be my main comments. Thank you.
Karin, now to you, Malte. The digital space is global by nature. For companies operating across different regions, such as Amazon, how is the AI governance and compliance organized? Is there some sort of regulatory alignment?
Between the different regions,
yeah.
I guess you mean. Well, let's say there is at least the effort, what we see in the text, that there is a strong reference to international standards. But, well, how this will turn out eventually remains to be seen from our point of view. And that's, I think, a general point I would like to stress. I think there's very broad agreement, and that includes Amazon, on the objectives of the AI Act and the support of innovation while introducing also guardrails, and that can be a mutual supportive process. If there's no trust, there won't be an innovation, and that's also very much in line with the Amazon philosophy, how to approach AI, this customer-centric approach, and moving from the customer then to the deployment of the technology. So that works well, and then indeed it comes in that not only Amazon, but also other companies, particularly in the EU, which is supposed to be cross-border, small companies which want to scale up, of course have an interest in a harmonized framework, indeed. Within the EU, and so far, it's good that there's an EU regulation on EU level, but then, of course, beyond. That's true, and there we hope for the work to come that will, particularly the European Commission, but also others, that there's a strong emphasis on adopting and building on international standards that are there, that the European Commission, particularly at the new AI office, will have this, well, intense dialogue, I would say, with other regions, such as the US, with the UK, with Japan, using the multilateral organizations that are there, Council of Europe, OECD, to really ensure that there is a consistency. There won't be, let's be honest, there won't be in the end probably no full consistency. And of course, also in multilateral organizations, you can agree to a certain level, but the aspiration should be there. And we encourage all players to work towards this harmonized approach. And then just to add, because yes, Amazon again is operating globally, We have a strong commitment, of course, to the EU, which is, I would say, maybe the second important region. But again, particularly smaller companies need this. And so far, to support European innovation, AI made in Europe, deployed in Europe, that is really important to eventually, thrive innovation.
That leads me to I think the question that everyone asks and everyone elaborates about, which is this new regulation with its complexity, with the burdens towards high-risk uses, is this going to foster innovation or and help European compete with US and China, or is it a burden too hard to comply with, and that will hinder actually companies that are European companies? What do you think, Malte?
Yeah, I mean, from a purely regional perspective, I don't know, maybe policymakers are in a better position to say whether Europe is competing well against the US. I said Amazon, I mean, we would not benefit from EU falling behind. The opposite. I mean, we very much benefit from a thriving digital single market. And so far, this is not the mindset that we are having here. Generally, does the AI Act help innovation? Does it help industry? The objective is there. Now it depends on how will these rules be specified. How will the delegated implementing acts look like that the European Commission is working on? How will this co-regulation, this code of practice look like, where also industry is involved? Will policymakers also leverage the expertise among private stakeholders? I think that's a very crucial point, because we are working here, the policymakers are working under very tight deadlines, and there's even a EU election coming, which will slow down things. Using what's there already, the international standards that are already established, the expertise that is there, consulting different stakeholders to get this expertise, and then to make this AI Act work in practice. So far, I think it's today, right? The Council adopted formally the AI Act, will be published now soon, and then 20 days later will enter into force. And first rules will apply from January, I guess, or maybe end of December. No, it needs to be January. So it's 6 months. 6 months, and until then, the definitions need to be clear, the prohibitions need to be clear, and then there's another the prohibitions, but then mid of next year, the general purpose AI. So this is very, very little time, and companies also need to have these guidances to adopt before the rules apply, of course, right? Because we need to consider that internally. So there's still a lot of work to be done, and I think, at one point, we may then agree whether the AI Act is a success story or maybe not, or maybe adjustment is required, but it's still early stages from that point of view.
Very Manuel, do you have a view on this?
Yes,
I know that you are very supportive.
It's a big task for both sides, for companies, of course, that want to comply with the AI Act, and also for the public sector, commission, different levels of the governance, because the governance of the AI Act is distributed between Commission and Member States, but the most important part is with this new service that are going to be created. They are in the phase of select the head of the service with some discussion about it, and they need experts. It's a very difficult moment, and after producing the guidelines, as you said before, and also at member states level, to organize ourselves here in Portugal. Probably it will be ANACOM responsible for the implementation of AI Act, but ANACOM was created decades ago with a different purpose. So probably also ANACOM need to prepare itself to these new tasks, very different from the tasks they have at this moment, and also recruiting expertise to do that. It's a long phase, very difficult, special. For me, the most important part is the chapter 3, the high-risk application, because for this kind of application, there are a long list of requirements, conformity assessment, impact assessment on fundamental rights for public bodies and some private ones, to select health insurance, or also to creditworthiness, as simple as that. So, but it's 2 years, I think so, the period for 24 months. But 24 months is a very, very short period. But more important than that, that's in 2 years, things are going to be different than today. So, because the technology changed too fast, but I hope so that this regulation is future-proof. But I'm not sure. Let's see. Let's do our work. But there are, as I said before, also the regulation have many articles about innovation and to promote, to push innovation at the European level.
Karin, what's your take on this?
Thank you. So I would say that we also have to take into consideration global developments. And today is not only the day the Council of the EU adopted the EU AI Act, it's the day the AI Safety Summit in South Korea started. It's the second AI Safety Summit. We had one last year with the UK, and it led to the Bletchley Park Declaration. And what happened actually is two things. First, there was a preparatory report led by experts in the field of AI, and mainly Joshua Benjo. And what they say in this report is that bias, we don't know how to mitigate so far bias in complex AI systems, and we don't know how to deal with the discriminatory effect of these systems. So this is somehow something to be considered and taken seriously. So yes to innovation, but yes also to protection of human rights. And I don't think that we need to avoid the two, to oppose the two, because in Europe and since the Enlightenment, we have also always considered that progress and so innovation is towards the betterment of the human condition. And this means basically to protect human rights. And not only that, but we already had this discussion about regulatory burden concerning the GDPR. And in the GDPR, we already have algorithmic transparency, for example. And what happened is that, well, in the end, companies not only complied, but other states all over the world starting adopting legislation which resembles the GDPR. So this is feasible, and not only is this feasible, but it is necessary. And what happened today on the first day of the Seoul summit is that a bunch of companies adopted the Frontier AI Safety Commitments. And what is this? It means that firms will publish frameworks establishing the risks of any new and powerful AI models they develop, and it includes the possibility of the termination of research and development into any AI products where those risks cannot be mitigated. And this is a commitment taken by companies by themselves. So it's a voluntary commitment. So we will see how it ends and what it consists in itself. But I mean, there are recognized risks, and there is no reason why. It's not true innovation if the risks are too high. It means that the benefits are not there. So I think this is the main thing we have to take into consideration. And again, from CADP and CADP Europe perspective, our point would be that interoperability should not be at the expense of human rights protection. And we should protect our European model. Because if we want to lead innovation, I think we should lead human-centric innovation. And this is the way we could make a difference. Because citizens are not stupid either. They have tried ChatGPT. They see that it hallucinates. Now we know that we have some deepfakes like ScarJo, Scarlett Johansson voice in the newest creation of Sam Altman was taken to impersonate, for their deep fake new creation, and we know it didn't go as they wished so. But basically, there are a lot of risks, and we shouldn't be think that we should sacrifice our human rights for so-called innovation, which is not proven. And I would just like to add something. Like, I will give you a very concrete example. Last summer, I was in holiday and I met someone doing what we call promotion immobilière, which means that to foresee what will be developments with regard to new buildings, etc. And the person told me that they were selling her some new version of LLM models to do this kind of predictions on the developments of markets. But what does that mean? How can you do that when you know that even the data that are used to generate information or knowledge from these large language models are not up to date? When you miss even the last 6 months, and when you know that the data come from basically internet scrapping, data scrapping, so it has no value at all. We are putting into danger a lot of our economies, because economy is not just about digital companies. It is about the companies which will use these systems, which are actually not really working right now. And we know that from the public sector. We had the Dutch scandal with the predictability system, which was used for benefits for poor families, and we know that we still have 2,000 or 3,000 children in foster care because their parents were accused of fraud. We also had a scandal in the UK, and we see it in the public sector because the effect is systematic. But we're going to see it as well in the economy. We really have to have a reasoned approach to the adoption of AI in the economy. And if we put guardrails, it will be good for our economy, and it will be good for the protection of our human rights.
Karin, now I'd like to ask Malte about how the AI Act fits within the broader regulatory framework in Europe. How does it align with other relevant laws and regulations, namely the GDPR, the MA, the SA, and you name it? This legislature was very prolific on digital regulation. So will we have an impossible regulatory puzzle?
Hopefully not. Maybe to start by, the general point here is, I think, a very important one. AI, at the end of the day, is a technology. It's a technology like many other technologies are available as well. And nobody can buy AI. You would always buy a product or a service or whatever that includes AI. So what does that mean? And there are many lawyers here in the room, so I will not give a lecture here. It means that, of course, if the product as such or the service is under regulation, usually it includes everything that's in there. And many horizontal laws don't really care about whether there's AI in there or something else. It's not listing these technologies in the product are regulated. It says this product will be regulated. And that is important when anticipating, and also now looking maybe ahead to the future. Are there gaps? And then, of course, the question, how does that AI Act fit into the broader landscape? It will be certainly a challenge to align now the AI Act with other horizontal and very important sector-specific laws. Even the AI Act includes this annex with all the sector-specific laws that are acknowledged that they address somehow AI. And then there's like GDPR, General Data Protection Regulation, which explicitly even refers to AI and specific use cases that are also regulated under the AI Act. So I think this mapping exercise will be a crucial one. And that's certainly also something high on the agenda for the European Commission and EU member states to now figure out how this will work together. And that links to another important point that is obvious: who will enforce, who will specify? Do companies, not only Amazon, but any company, have to go to 2, 3, 4, 5, 6, 7, 8 different national authorities to check, am I allowed to do this, or am I, under which regulation am I? Are the rules consistent? Is the GDPR consistent with the AI Act? And then we are talking about one country now. Let's talk about Portugal, but you go then maybe to Anacom and a few others. But if you then have the same product in other markets, you will have to do the same there as well. And maybe then there's another authority which have a different mindset. So that...
So after all, yes, regulatory fragmentation.
Yes, I thought so. So I'll stop here. But indeed, there are a lot of question marks, and and so far a lot of further work.
Yeah. Maria Manuel, Leitão Marques.
No, that is a very important point because it's a package. It's not only AI Act, it's the last one probably to be approved, but there are others before. The Digital Service Act, the discussion was the same, whether we are going to stop innovation or not, or are going to attract more companies to develop service or not. But we decided that we need to regulate because before probably only data were protected, but now we need other kinds of protections, and also maybe in the next mandate of the Parliament we are going to regulate in the problem of children protection in a digital world. Internet Safe for Kids is a project we have in the Parliament. But it's not only the Digital Service Act, it's not only Digital Market Acts, it's also Data Act, Data Governance Act, and the European Health Data Space, and maybe other data spaces we are preparing at the European level. And this is very important to organize and to protect, not only to protect, to organize our data in order to use them to develop new public and private service, not only to improve our public service. And you can do a lot of things, namely in terms of health, not only to develop new drugs and so on, but also medicines, but also to better manage our public service and our private service using AI and using data, protecting them, of course. Because I totally agree with you that that no one, even people favorable to innovation, no one wants innovation that they can trust. So we need digital human-centered, digital service human-centered, and AI human-centered. No one will use artificial intelligence, to give you an example, to help detect cancer if the software keeps giving false positive or false negative. And there are many other examples that we can explain. And so for companies, I totally agree with you, and special for small ones, it's better to have only one legislation, one law, than 27 or even more. It's why it's very important if you can converge with Korea, with Japan, with the United States, of course, maybe with China, why not? More difficult, but possible, to the same principles and to same regulation. I know it's very difficult because I went to the United States, and at the moment it's very difficult to have a majority in the Congress to approve no matter what regulation, but special this one. But there is an executive order of the President Biden, and there are some initiatives from civil society and also from companies, and also in China, the different approach on privacy and on protection of citizens' data and on human rights, of course. But at the end of the day, companies that export their service or produce service or products based on AI for the European market, they need to comply with our rules. It's better to comply only one with the same rules than with different ones. So international cooperation for that purpose, and also the work of the Council of Europe is very important, but the United Nations too, and the treaties, the work we are doing in the United States, and so on.
Yeah. By the way, in the United States, we have an initiative, a bipartisan initiative to regulate AI. I don't know what will be the success of this initiative. I'm a bit skeptical. But I think that Colorado has just approved an act on regulating artificial intelligence. So at state level, maybe such as what happened with privacy in California and so on. So maybe we have regulation.
California, the GDPR was.
Yes. So the Brussels effect may be taking form in some countries. Well, I before giving some time to questions from the audience, I'd like to ask you mentioned the idea of regulation being trying to be future-proof, but we saw what happened between the initial proposal from the Commission and the final text. So the explosion of the generative AI after ChatGPT changed the game and also obliged the legislators to change a bit the approach from the AI Act from only risk-based approach to somehow technology-based approach towards general-purpose AI and systemic risk general-purpose AI models and systems. So do you think that this will be really future-proof? And this is a question for the three of you. Karin, do you want to begin?
So first, with regard to what you say regarding general-purpose AI and the specific legal regime within the EU Act, I'm not sure it is because it wouldn't have fit within the risk-based approach. It might be that there was not an agreement on what kind of legal regime should apply to it among member states. So this was a compromise. Second point, and even Kaisener, who was working for Axel Voss, somehow if you read what he has been writing recently, some of them have been questioning whether we shouldn't have had a rights-based approach, because a rights-based approach based on principles means that you can operationalize it. However, you have a common basis and it is future-proof. And lastly, we can give the excuse of, we suddenly discovered ChatGPT. But if you take the case of Singapore has been regulating AI, or at the time maybe the term was not that fancy, but since 2019, and its regulation, its regulatory regime was based on GPT-2. So for some country, it was no news. So you see, it's really a complex matter. It is not just about whether it will be future-proof or not. I think if we have enough flexibility, we can adapt. I think as far as human rights protection is concerned, we always have the EU Charter of Fundamental Rights. And we hope that the Court of Justice will continue with its approach and build its case law based on the Charter of Fundamental Rights, which will allow a certain harmonization among the different strands of legislation. And just one legal point, we already know what will be the articulation between the GDPR and the EU Act. It's written in the EU Act. The GDPR takes precedence. So we will see. It's a question of putting the different pieces together, but hey, I think all lawyers will be very happy because they're going to have a lot of work.
No, for lawyers, it's a lot of work.
Thank you, Karin.
It's my way.
Malta?
Maybe.
It's probably too early for that question. Is it future-proof? Remains to be seen. That would be a strong suggestion from our side. Focus now the AI Act to get this right. There's a lot of work to do. Once this is done, take a step back. There are EU elections also now. What needs to be done to really support positive innovation in the EU? Are there gaps? then there should be maybe a gap analysis before moving on, and then there, considering also the pace of innovation, voluntary commitments can play a role, can complement binding rules. So there are many things to be further discussed, but let's not do the third step before the first is properly done. So that would be the suggestion here. Yeah, by this I pass on to my dear co-panelists.
So on this point, I'm not sure we are going to see, but there are more than usual flexibility in the AI Act, in this regulation. A lot of delegate acts and implementing acts. We can change the annex and the list of high-risk applications to remove some of them that finally we discover that there are no risk, it's possible, or to add other ones. So maybe we have some tools in the AI Act we can adapt. And the other point, very important from my point of view, we keep the governance, not all the governance of the AI Act, but important part of them at European level. We did that to the SA, we did that to the MA, and we did that with the AI Act, and probably with this kind of digital regulation, we need the governance also, the implementation powers centralized at Commission level.
Thank you. Now we have some time for questions. So who wants to intervene?
I can start.
Yeah. Guilherme?
First and foremost, thank you very much for your intervention. It's been very enlightening on some of the aspects that you covered on this fascinating subject, so broad that we could spend days, weeks, months discussing it. There are a couple of things that I don't agree with you, but there is one centric and fundamental thing that I agree, that the AI development should be human-centric, and that should be the baseline for us to use it. While the European community and the European Commission has been discussing the rules, the guidelines, the rail guards, there is something that we haven't seen yet, is that how is the European Union also addressing the lack of skills and the human resources to not only enforce the regulation, but also to allow that all the companies, either public or private, could use regulated AI to capitalize on innovation. We're talking about the technology, like Malta said, that has been around for 70 years or so. So AI has been coined in the late 50s or so. There's nothing really new in terms of the conceptual mathematical models that has been developed in the last 40 or 50 years. The big difference today is that we have the technology that allows us to process huge amounts of data in real time to provide actionable information so that we can take decisions. But we don't have enough people to do it. So first question, is the European Union doing something in terms of guidelines or even law that would make it mandatory for AI to be taught in schools right from the beginning? One. A second, are there any plans to capacitate and to give any kind of budget funding for both private and public companies to train their own people to not only use correctly, but also to foster innovation in European space? Because we know that this is a race that we must win, yes or yes. Otherwise, there is a huge risk for democracy if we leave the AI race being led by non-democratic countries.
I you to introduce yourself. So, Guilherme, do you want to introduce yourself?
I'm Guilherme Dias. I'm work for a software company, an American software company called SAS. We are the founders of AI, so to speak. So we've been working on this space for 48 years now, so it's nothing new for us. And I'm also a technology guy with engineering background, but also very sensitive to the human aspect of technology, because technology, AI is just another tool that will for sure help us move humankind into a better direction and create better conditions so that we can have stronger democracy and better healthcare and better education and such.
Thank you, Guilherme. Maybe we can take two more questions and then we'll give the floor to the speakers. Unless you prefer to begin, since there are no volunteer now.
Only one information, and I'm available to share with all of you if you are interested in knowing. I wrote a letter to the commissioner, to the Vestager, to Ursula von der Leyen and the Commissioner Breton, exactly on the problem. We need to federate our resources at European level, as the United States are doing also. Our public and private resources, because it's a very critical point, and also, of course, to invest in new skills and the competencies on AI literacy, not only for specialists. We need a lot of AI specialists, but also for all of us, because if we call about algorithmic transparency of if I'm going to the bank and now I'm not select for a credit or for a health insurance, I need to ask why, where, what kind of data are you using to exclude me? And this is very important in our daily culture. It's very important. AI literacy for everybody. It's now the basic digital skills. They include some aspects of AI, but of course also to specialists. It's why I wrote this letter to the Commission in order to initiative to federate our resources, a kind of CERN or European Special Agency for AI. But you know also about the initiative of the Commission on AI factories that we approved in the Parliament in the last session, 25th April exactly. That is also a way to join computing capacity with resources, but also I'm not sure that we are able to answer, but we are doing our best in order to have resources from a financial point of view, but also for human point of view to build this system, to be innovator, and also, of course, to have AI, human-centric AI.
Yes, I think investing and the ability to have capital to invest in innovation may be one of the main differences between the European Union and the US.
But special risk capital, it's not only a problem.
Yes, no, of course, I'm talking about private and public capital. What's the role of a private company in this question?
Yeah, I appreciate that you bring up this topic. It's obviously a crucial one. I would like to, at the occasion, I would like to highlight a study that Strand Partners has published in February, commissioned by Amazon Web Services, which is extremely helpful and insightful, particularly because it's about unlocking AI potentials. And Strand Partners comes to the conclusion that the EU could have an additional 600 billion gross added value by 2030 through AI, if the current growth rates continue. And for Portugal, by the way, 61 billion, which is also quite significant, and a very above average adoption rate for Portugal. At the same time, one of the main obstacles is the lack of skills. So companies, 71% of Portuguese companies say they don't find the people. They don't find the people. And I mean, considering now looking at Amazon, where we deploy AI currently everywhere. In robotics.
In the public sector.
Yes, I mean, it's not like a niche product. We deploy it in our Alexa voice assistant for accessibility, in robotics to improve workplace safety. Then we provide AI, generative AI to third parties through Amazon Web Services. So across the whole company, we also need to upskill people, that they understand at least the basics or in this specific context. So it's a huge effort for us internally, but of course then also for the broader society, and that is probably a collective a collective challenge. And there's certainly also not the one size fits all and the one solution and then it's all fine. It needs to really, private companies can support that. So we have also commitment to support classes. We provide to business customers classes to upskill when using AI. And many more measures are required, but there is urgency, I would say.
Yeah. And Karin, I think that also the need to reskill those who lost their jobs and will lose their jobs because of the development of AI is something that should be tackled at international level. What do you think, Karin?
Well, I think that in any case, AI will also create new jobs. So indeed, the main question is a question of skills. It's technical skills, of course. And since we have the EU Act, we have already data protection officers positioned, but we will see how companies will plug in the AI bit into this mix, into their governance. Honestly, what we've seen as best practices, if it is linked to the DPO's work, but indeed you have people who are trained, but there's also a general issue of civic awareness with the issues of disinformation and misinformation. It is very, very important, and some countries in the north of Europe, for example, are already having programs to educate children or adults as well, so that they warn and they know. They get some tips on how to distinguish the truth from misinformation and disinformation. This is absolutely key also to safeguard our democracies, because when you don't know anymore what is true and what is not true, then what do you trust in? It also weakens our trust in our democratic institutions. And lastly, as far as programs, specialized programs are concerned, all efforts are welcome, but if there are some trainings, in higher education or even younger, because we know that even as far as mathematics is concerned, we are missing some people. It's not just at the level of engineers. The level of mathematics proficiency in Europe is not that good. Some countries are better than the other, but it's not that great, right? So in this regard as well, I think it should be the responsibility of public education and of states, because who governs the programs governs somehow also the minds. And we know that we at CADP, we do offer trainings, and it's free program and it's policy clinics, and we have people from big techs coming to us, as we have people from civil societies, we have people from public institutions, all are welcome. But you also have some big techs or other companies developing this kind of programs. And the point is that they are vehiculating their own point of view. And it is good. It is good to have ours as well. But I think there's a key role to be played by states in this regard.
So, one more question or two? Yes, Ines? I think we are not hearing you.
Is it not? There
Okay.
you go. Sorry. So my name is Inês Sousa Mendes. I'm a competition lawyer with Weil Gotshal in the Brussels office. And I wanted to know what's your opinion on whether now with the end of the term of Commissioner Vestager, if something will change in terms of the efforts being put into the regulation of the digital space and AI in particular.
Maybe I'll take one or two questions more before giving the floor to the speakers. Anyone? No? So
I'm not convinced that, but it's possible. No, of course, Commissioner Vice President Vestager push a lot on regulation. Also, Commissioner Breton, I must tell him, both and the Parliament. But I think there are many dossiers already open in the Parliament. For instance, on liability. AI liability is one of them. It was delayed because of AI Act, but probably it starts with the new parliament. Also for kids, there are a directive, and the parliament when I arrived the parliament 5 years ago, we start discussing digital. There are some groups more sensible to these points, other groups not very sensible to them. But now I think the digital is a very important issue. But the most important point is the implementation of the legislation we approved during this mandate, because it's Digital Service Act, DSA, DMI, Data Act, Data Governance Act, the European Health Data Space, and IA Act. It's huge to implement them. And the main task, and the Parliament also, is of a special committee to follow the implementation of these acts. The implementation is a very big, huge task for the new commission responsible by DG Connect and also by DG Competition, and probably the vice presidents that replace Vice President Vestager. I hope we are going to continue and not stop.
What do you think, Malte?
We will only know when there's a new commission, I think. It depends on many factors. I would, and I stressed that earlier today, right? I would hope that policymakers take a step back and really think about, okay, what is really needed as next step, because there's a lot of non-legislative work to be done. And it's, of course, not a solution to adopt laws and then moving on to the next law and the old law is not properly enforced. That's
but
also not...
What I said is complementing. Liability is very important.
Yeah, and liability, I mean, that, as you said, was already published a while ago, and that will be now continued, and we heard about some other initiatives. We didn't talk about copyright, for example, where we would also hope that maybe without legislation there could still be a support how to better enable rights holders to make benefit from this opt-out through a technical standard, for example. So there are also other things than legislation that could be.
Regarding liability, it will be discussed in the last panel, and I think my colleague Enrique will have a lot to say about that. But before that, Karin, do you want to add anything on this regard?
We regulate a little better with the revision of another directive, but not specific to AI, but to software, to include software in effective products.
Yes, as we said, I think that first, even with workers, you say there's not much in the US, but for example, even today, the Biden administration has unveiled its guideline to protect workers from risk of AI. So even them are conscious of the fact that there will be some impacts from AI, and there is already some impacts. It's all over the world. We will see how it evolves. With regard to how are we going to process, I will go back to what Maite said, which is that governance and enforcement will be key. So what we haven't discussed, and I guess you will discuss in the last panel, is about the representative action directive, so class action directive, which is actually applicable to the whole digital package. So in order to protect rights, it's going to be interesting. And lastly, I would like to give the example of the UK, because the UK are always somehow smart in terms of pragmatism. And what they did is that they put all the regulatory agencies together and they said, okay, now you have to coordinate. This is probably what we're going to have to do with regard to the EU Act, the DSA, etc. However, there's a key point I would like to mention, which is that traditionally with the GDPR, we had the independence of the oversight agencies, which is a key principle. However, it has been weakened with the EU Act. And we see, for example, that in the Netherlands, we have a dedicated unit in the Data Protection Authority, which will be in charge of AI, which is in charge of AI. So there is independent oversight. However, if you take the example of Spain, you would see that they developed what they call functional independence, but there is no organizational independence. I'm not sure how you can get functional independence if you do not have organizational independence, but basically the governance of the agency is filled with people from the economy, digital affairs ministries, nothing from justice, nothing from fundamental right protection, and so on and so forth. And it is not an independent agency. So there are also some worries as far as these new agencies are concerned. And you talked about skills, but they also need skills, and they need human resources, and they need financial resources. So it's all good in papers to have enforcement agency, but if they don't have any means to enforce the law, then they cannot do it. So this is also a key practical aspect that we need to tackle, because these agencies will be key in helping, could be key in also helping companies comply with the law. They could issue guidelines to make things clearer in the national realm, and they could coordinate in order to do something which is somehow practical. And personally, as far as CADP is concerned, we favor like regulatory sandboxes within data protection authorities or national market surveillance authorities under the EU Act, instead maybe of an over standardization. Because the risk with standardization is that since it is mainly controlled by the industry, and it's nice to have, of course, input from industry, but not just them, there is a risk that it will not strictly apply the EU Air Act, and it will be used in order to change somehow in the operationalization what was agreed under the EU Act. And I can tell you that CADP and other organizations will be ready to go before the Court of Justice in order to attack the standards, which are now called social technical standards, not just technical, but if they are social, if they concern society, are they still just technical standards? This is a question, and this is a democratic standard. And with regard to the delegated act, which will be adopted, we will also go to the European Parliament to see whether they wouldn't go before the Court of Justice in order to make sure that if there is a delegated act which does not respect the word of the EU Act, it will be squashed by the Court of Justice. So some would say, oh, this is not good because, again, there will be some delay. I would say that from our perspective, nothing should prevail over the protection of fundamental rights, because it means getting innovation right. So that's it.
So thank you, Karin, and thank you to the speakers of this panel. So we'll have a coffee break now, and we'll be back in 15 minutes. Thank you very much.